everybody, welcome to iExamBee's LegalBee. This is Amrita, your law faculty here at iExamBee. In this video today, we are going to discuss all the landmark judgments that have been passed by the Honorable Supreme Court and High Courts of India during 16th of July to 31st of July. ये सीरीज हमने स्टार्ट की हुई है एक्सक्लूसिवली एट LegalBee to make you all aware of the landmark judgments that are being passed every 15 days by the courts in India. Why you need to know these landmark judgments? First of all, if you are preparing for any judiciary examination or any other competitive examination where you have legal current affairs, तो ये judgments के ratios अगर आपको पता हो तो ये आपको काफ़ी helpful होगा. Even if you are practicing in the court of law, then definitely you have to be updated with the judgments that are being passed recently, the ratios, क्या points of law discuss हुए हैं, तो उसका एक gist आपको पता होना चाहिए. So that is the reason we have started this series at LegalBee. अगर आपने बाकी के videos miss कर दिए हैं, then you can check it out in the playlist section of LegalBee. Every 15 days we come up with the judgments of every month. Okay, so in a month you will be getting 2 videos and आप इन PPTs को डाउनलोड भी कर सकते हैं. ये डाउनलोड करने के बाद आपके पास आप रिकॉर्ड भी बना सकते हो. यू कैन मेंटेन अ फाइल और अ फोल्डर इन विच यू कैन हैव ऑल दीज जजमेंट्स प्रिंट्स ऑल्सो विद यू, जो PPTs मैंने आपको दिए बेसिकली. सो दिस इज़ वेरी हेल्पफुल फॉर यू ऑल. And also if you have any queries, you can write to us at hello@iexambee.com or in the comment section of this video. Don't forget to subscribe. Landmark judgments from 16th of July to 31st of July 2023. Central Bureau of Investigation versus Shyam Bihari and others. This judgment was passed on 17th of July by the Honorable Supreme Court of India. It was an appeal that was filed against judgment and order of acquittal of the High Court of Uttarakhand at Nainital, and this was relating to a police patrolling party who had shot dead a man, and the deceased who has died, his accused, were acquitted by the lower courts. But then subsequently the case came to Supreme Court of India. In this, the court has propounded the theory of benefit of doubt. What was it? Everybody knows what is theory of benefit of doubt, but इस केस में उसे कैसे अप्लाई किया गया है ये काफ़ी important है. Court has mentioned the logic exclusively. If the accused policemen were to use their rifle to fire shots, why would they use a country-made pistol to inflict injury to the deceased? यानी कि उस crime scene में जो facts थे उसके हिसाब से court ने एक judgment लगाया है that what can be the probable circumstances. The circumstance that the accused persons were required to patrol that area and had left the police station for that end on that fateful night is a circumstance which is not conclusive to turn the tables on the accused. So until and unless we get a conclusive circumstance towards the accused, we cannot punish him. That is the benefit doubt theory. So in this case also, the accused had, if there was a probable story that was being possible which was totally opposite, that the accused, if he would have arrived at the spot late, then in that case how we can assume that they have only shot him dead, they were only having a common intention to do that. So इस तरीके से कोर्ट ने ये कहा है कि अगर probable story है जो कि accused को protect कर रही है, then benefit of doubt theory will come into picture and you cannot punish him. So that is how court has come to a conclusion here, and also the eyewitness testimonies were doubted and discarded. So that is the reason benefit doubt theory was applied, and again acquittal was confirmed. Indirabai versus Oriental Insurance Company Limited and another very important judgment in which the question of law was relating to disability of a laborer. She actually met with an accident in her course of employment, and the disability was 40% because her one hand was not working. Medical certificate also was given in such a way by the board commissioner. He also found that the appellant is unfit for labor, and she lost the grip of one of her left hand. But then what was the nature of work she was doing? She was working as a loading or unloading laborer. So if she is using her both the hands in her nature of work, then we cannot say that she was disabled only 40%. The court has increased her disability to 100% instead of 40. And this was the very very important point that was discussed in this case, that we cannot just very mechanically observe this. We have to see that what nature of work she was doing. Will she be able to do that work again with one hand? So ये point यहाँ पे discuss किया गया है, and according to that the compensation also has to be awarded. So section 30 of the Employees Compensation Act was discussed in this case. Arvind Kumar versus State of NCT, Delhi. In this case, the Supreme Court has convicted the appellant under Section 302 of IPC, which has been confirmed by the High Court. Trial Court has convicted, High Court also has convicted. But then when the case came to Supreme Court, again 302 has been modified to 304A. ऐसे काफ़ी instances हमने देखे हैं. This is a recent one. So let us see what was the reason. The statements that were made after the incident. Statements do have a connection with the incident. They were made spontaneously as per res geste of doctrine of section 6 of the Indian Evidence Act. The theory of the prosecution was that the appellant had intentionally fired in that particular case. हमें बहुत ज़्यादा detailed facts की ज़रूरत नहीं है. We just need to understand the point of law. So when the accused went towards the deceased, at that time he was preventing him to use the telephone, and in the reaction of the or the action of the deceased, which result in the SAF getting entangled with the chain attached to the appellant's belt, which led to accidental fire from SAF. Therefore, the accused spontaneously reacted by telling what she has got done from him. So in this case, the circumstances, if we see carefully, that is what is res geste doctrine, we are able to understand that there was an accidental fire that took place, because whatever he reacted after the gun had fired, whatever he reacted, that statement has contributed to res geste doctrine, and it says that the act was not intentional. The trial court and high court had confirmed that 302 thirdly clause में ये murder होगा, but नहीं, that has been converted by the Supreme Court into 304A, that is death by negligence over here. Teesta Atul Setalva versus State of Gujarat. This is a petition which is challenging order on a bail petition which was rejected by the High Court of Gujarat. Single judge bench. The charges that were there against accused are section 468, 469, 471, 194, 211, 218 and 120B of IPC. So in this case, the grounds on which bail can be granted are basically discussed, so that everybody should keep in mind, which the Supreme Court has reiterated, that whenever a bail application comes, what factors need to be considered. Prima facie case is there or not. Whether there is a possibility that the accused will tamper with the evidence or influence the witnesses. If not, then definitely we should give him bail. The possibility of the accused fleeing away from the hands of justice. So these are the three things that need to be considered. We do not go into the facts of the case. Court also mentioned, nevertheless, gravity and seriousness of the offense also need consideration. So in this case, the High Court has actually exercised its powers, and even if the FIR and charge sheet both were filed, it was not challenged under section 480 of CRPC or under article 226 or 32. So it is not permissible to contend that prima facie case is not made out. So this was also pleaded that it is to be accepted that no bail application could be entertained. What was another ground that was said by the state in that particular case, that they have not approached the High Court for quashing their FIR or charge sheet or criminal proceedings. So court said that if they have not filed, that does not mean that bail will not be granted to them. Even if they have not filed it, then also we cannot just rely on that and reject the bail of accused. So this was the observation made by court. Boini Mahipal and another versus State of Telangana. In this case, the appeal was filed by accused number 3 and 4. So there were 4 accused. All were charged under 302, 303, 504, 323 read with 34 of IPC. So in this case, they had been convicted when the question came to Supreme Court. Supreme Court held that whether the judgment and order of sentence convicting these two people, accused number 3 and 4, is to be sustained or set aside, that we have to see. So court said, in the absence of any incriminating material or other corroborative evidence pointing the participation of appellant accused in the incidents, conviction of them under 323 and 34 cannot be sustained. We need cogent and positive evidence to prove the facts, and the participation of the appellants need to be proved. Just because they are the co-accused, we will convict them, ऐसे नहीं हो सकता. So on this hypothesis, the conviction was not sustaining. Here also court has given these two people acquittal. Gurbachan Singh through LRs versus Gurcharan Singh through LRs. This court is relating to the appeals that were filed against judgment rendered by Punjab and Haryana High Court, that is in a civil regular second appeal. What was the crux of these appeals? That was relating to a property dispute. And basically what is important here for us to understand, that in this instant appeal, what court has observed about appeals under section 100 of CPC, that the section itself dictates an appeal shall only be maintainable when the case involves a substantial question of law, or that the appellate decree has been passed ex parte. यानी कि 100 of CPC में अगर आपको अपील फाइल करना है, what are the necessary requirement? The question should be substantial question of law and not just question of law that is having general importance. ये दो चीज़ों को कोर्ट ने इसमें डिस्टिंग्विश किया है. And अगर ex parte degree file हुआ, that can also be entertained. So that is how court has mentioned several citations here. आप इस वीडियो को पॉज करके इन जजमेंट्स को भी नोट डाउन कर सकते हैं, इस जजमेंट को भी जाके डाउनलोड करके पढ़ सकते हैं. Take this detailed citations. So here court has applied this, that the general importance words cannot be just entertained every time. We have to see whether the question of law is substantial in nature, and then only we will understand. And if it is only substantial question of law and substantial question of law of general importance is not there, then also the appeal can be entertained. Chenupati Kranti Kumar versus State of Andhra Pradesh and others. In this appeal, appellant is working in a company in USA, and a case was registered against him under section 498, 403, 406 of IPC. Also under the Dowry Prohibition Act, section 3 and 4. He against his wife had actually filed it. So when he came to India for the death anniversary rituals of his father, that time the cause of action arose, this was said. And then when he came, so his passports were seized by the police, and then it was the question that is here, which is relating to the whether passports can be impounded by the police. So court held that the police can just keep the passports with them, cannot impound it. The police has to give it to the passport officer. The police officers are not having power to impound the passports. So this was relating to the passports case, and Manika Gandhi case was also of course referred over here. Nagar, BP Nagar and others versus Rajpal Sharma. This appeal is an important point, that is relating to valuation of suits. Now valuation of suits is what is discussed under Suits Valuation Act, and Court Fees Act is important over here. So what was the question over here? That the value for the purpose of jurisdiction in a suit is another question which often arises that needs to be considered. Court said that the question has to be decided by reading section 7(4) of the Court Fees Act and section 8 of the Suits Valuation Act. So when we read both the sections, we understand that the section 8 of Suit Valuation Act provides that value as determinable for computation of court fees and value for the purpose of jurisdiction shall be same. यानी कि jurisdiction के लिए जो हम value calculate करते हैं and जो value हम computation of court fees के लिए calculate करते हैं, दोनों भी same रहेगी. So this was the technical point that was discussed by the Supreme Court in this particular case. ये जजमेंट थोड़ा सा आपको समझने में शायद ट्रिकी हो सकता है, तो आप क्या कर सकते हैं, इन सेक्शंस को पहले जाके पढ़िए एंड देन यू मे अंडरस्टैंड दिस रेशियो इन मोर डिटेल. Chief Executive Officer Zilla Parishad Ahmednagar and another versus Suraiya Rafiq Khalifa and others. This is a judgment of the Bombay High Court, bench at Aurangabad. It is relating to Employees Compensation Act again. The employer's liability in case of accidental death or injury was considered over here, and the employee is actually contractor's employee, means appointed through private contractor. So what was the question? That whether principal employer is liable to that extent that he is to include penalty and interest for default also. What had happened? A water tanker driver, he had died due to cardiac arrest during his course of work. So the question was this only, that he will be getting compensation, but the principal employer, not the contractor is also his employer, but the principal employer over here, he is not liable to pay the penalty for default and interest for default over here. In this particular case, the liability will not go to that extent. This is also important one. Let us see one more judgment for today. Goa Foundation versus State of Goa and others. This is relating to Bombay High Court, bench at Goa. In this petition, High Court of Bombay has held, now this is important for the current affairs point of view also, environment से related भी कुछ judgments आते रहते हैं जो landmark होते हैं. So that also we should know. That's why I picked up this case discussion. That if there is a there is no legal impediment if the Goa government declares Madai Wildlife Sanctuary as a tiger reserve, even if the final notification under the Wildlife Protection Act 1972 has not been issued declaring some areas within Madai as sanctuary. यानी कि आपको फाइनल नोटिफिकेशन ऑर्डर की वेट करने की भी ज़रूरत नहीं है. द गवर्नमेंट इज हैविंग द पावर टू डिक्लेयर इट immediately as a tiger reserve. Then only the purpose will be solved. You don't have to wait for 3 months for that purpose. This was mentioned by the court in this particular judgment, so that immediate action can be taken by the government over here, and you don't have to wait basically for the final notifications. Notifications are passed for such kind of things, no doubt, under section 26A. You can read the section also, so that the area gets protected. But then if you have to take immediate action, you should take it. I hope you all are getting benefit from all these kind of videos. If you have any queries, do reach out to us. Don't forget to subscribe to LegalBee and prepare 50% faster with iExamBee. Thank you everybody. Have a good day.